So, is this an example of two-tier justice? Well, what I'll do is I'll set out the facts as objectively as I can, and I'll let you decide. I'll be very interested to see your comments on this one. So what am I talking about? You may recall a little while ago there was a guy who set fire to a Quran outside the Turkish embassy. And there was another guy who went off, collected a knife, and then came out and started chasing him and saying, "I will kill you." And eventually sort of, got him on the ground. Didn't actually use the knife, but it did appear to be an assault. And perhaps unsurprisingly, he was duly arrested and charged. Now, one thing that's probably worthy of note, and I'll mention why when we get onto it shortly, is that he was asked, because they didn't recover the knife at the time, he was asked to send a picture of the knife. It's like, "Hello, we're investigating these crimes. Could you actually assist us? Could you send us a picture of the knife?" And he sent a picture of actually a palette knife, sort of rounded end, completely blunt, sort of thing you'd use for painting or scooping a cake up or something like that. And that wasn't the knife involved. The knife involved was actually a sharp pointed bread knife. So he was duly charged with possession of a bladed article and common assault. He pleaded guilty, and we now have the sentencing remarks from the judge, and I will link to those in the description so you can read everything, and also my vaguely accurate thing, you can actually see exactly what the judge said, because I'm bound to get a few bits and bobs wrong. He was charged with possession of a bladed article and assault, and the judge, he looked at this and he applied the sentencing guidelines. And he said, well, look, this is clearly, possession of a bladed article. I mean, that is an offence. It's the old, you can't have a blade that's, a bladed article. You can't have something with more than sort of 3 inches of sharp bit. It can't be locking and all that sort of thing, unless you have a good reason, So if you're a carpet fitter, for instance, you might need one, or you're on a camping trip or something like that. But there's clearly no defence here for that. It's not a good reason to have a knife to go around and threaten people with it. So perhaps unsurprisingly, he pleaded guilty, and he also pleaded guilty to the common assault. Now, the judge applied the sentencing guidelines, and he said, I think this is a category A2, so that's like the most serious in terms of culpability, but the medium one in terms of potential harm. Because he said, well, at the end of the day, nobody was actually hurt here, and he was just scaring people. So he received a sentence. The judge said, well, what I'm going to do is I'm going to say the starting point here for this sort of offence is 6 months imprisonment. I'm going to give you a bit of a discount because you've pleaded guilty, so I'm going to knock a bit off, but I'm going to put some on because effectively you tried to mislead the authorities by sending them a picture of a different knife. So I think that all rounds up to 6 months. And with regards to the common assault, I mean, what's the definition of common assault? Technically, it's just putting somebody in a person of reasonable firmness in the apprehension of the imminent and immediate use of force. You don't actually have to make contact with somebody for an assault. It's just enough that you effectively, make them think that something might happen, that they might be in danger. With regards to the assault, the judge said, well, I'm not going to treat that, I'm going to wrap that up within the 6 months. So any sentence with regards to common assault, applying what we call the totality principle, where even if people are charged with multiple offences, you sort of, at the end of the day, you just want a sentence that seems to reflect the overall criminality. And the way you can do that is either you can impose sort of the full sentence and make them run concurrently, so they're all being served at the same time, or you could sentence individually and make them be consecutive, so they've done one after the other, but then you just knock them down a little bit to reflect the totality. But here he said this is worth 6 months. However, he suspended the sentence. And why did he do that? What are the reasons for suspending a sentence? 3 main reasons. Basically, there's very significant and special mitigation here, something that takes it out of the ordinary. Not just enough, I feel sorry, I regret it. There's something very unusual about the circumstances, and almost like, oh, I can see why it was justified, sort of thing. There's a realistic prospect of rehabilitation, and it's better, the person is more likely to be rehabilitated if they're not in custody, if they're out, so they could do sort of with probation supervising them and doing think first courses or anger management and all that sort of thing. But the judge here said, actually, I'm going to suspend it on the basis that it would have a negative impact on innocent third parties. So what was that? Well, they said this guy, he's 58 years old and he does a lot of charity work in his local community, and if we bang him up, he won't be able to do that, and it's not fair on people he helps out. So the judge suspended, and he suspended it for 18 months. So what does that mean? What's a suspended sentence? Well, if you basically are on a suspended sentence and you commit any other offence within the period of the suspension, then the rules say that notwithstanding what sentence you get for the new offence, the judge should also activate the suspended sentence in full, unless it would be manifestly unjust to do so, in which case then they don't have to activate it, or they can activate a lesser bit. So it's like, well, you should be serving 6 months, you're in breach, I'm going to make you serve 2 months of it or 4 months of it, something like that. So he's got to be on his toes. He's got to keep his nose clean. Also, he said you will do 150 hours of community service, pay the contribution to prosecution costs and the victim surcharge. So he's got to do his community service bit. Now, is there anything unusual in that? Well, in some respects, the judge's hands were tied, because he could only sentence on the offences that the CPS chose to bring. And they chose to bring just simple possession of a bladed article and simple common assault. And some people said, well, could there be more things there? Well, yeah, because there is a specific offence of actually possession of a bladed article, but using it to threaten people. And obviously that's a much more serious offence, because possession of a bladed article is you'd just be walking down the street, not doing anything, the police stop you for whatever reason, find it, you've committed the offence. So in this particular case, I think it would have been very open to the prosecuting authorities to say, no, we're going to charge you with the threatening thing, because he was saying, I'm going to kill you. There's another offence there, of course. There is an offence, a separate offence of threats to kill. That in itself, and that's a very serious offence, threats to kill. The test there is you must make a threat, and it must be something that a reasonable person would believe was a threat. So, sort of my mum going, I'll swing for you, next time I block her in a driveway or something like that, then, she probably wouldn't be prosecuted there. I mean, notwithstanding all my emails to the CPS. So there's another offence there. But the other offence I think they could have gone for is attempt to pervert the course of justice, because he sent off that picture of the palette knife, and a palette knife, because it doesn't have a bladed edge, then he wouldn't have committed the offence. So it's not like he's trying to make it look less serious, he's trying to make it look like he didn't commit the offence. And that's something that actually is normally taken very seriously. And usually that attracts a separate penalty that is usually consecutive, because the argument is that whatever you did in the substantive offence, if then you try to cover it up, and people have been done for perverting the course of justice, like they've done some twocking, it's like nicking a car or something, and then they've burnt the car out to get rid of the fingerprints. And they said, well, that's attempting to pervert the course of justice because you're making our job harder. I mean, it's really weird. There's no duty on you to make it easy for the police to investigate your offences, but at the same time, you can't do anything actively to make it harder. So, for instance, the washing of blood-stained clothes. I mean, that's one that gets people, either the offender themselves or, their mum. They run home, and actually I had a punter once. It was an attempted moider, and he got convicted because he managed to leg away from the scene. Luckily the guy survived. It was a very horrendous attack. And basically they followed the blood trail back to his girlfriend's house, but then they found him just in front of the washing machine naked with his clothes in there, just staring and randomly pressing buttons. Then the sort of the commentary by the police about that, because they're actually quite sympathetic to him. They were sort of going, oh well, these things are more complicated, and these new ones, because it was like a digital one. And they did sort of say to him, look, even if you'd have washed it, we'd have taken the lint trap, so you'd have been caught anyway, so you don't need to feel bad about it. But yeah, that does surprise me that they didn't go for that, because normally that's a very serious offence. I mean, sometimes they'll drop it down to obstruction if you plead guilty. I mean, a very common one there is, you agree to take points for somebody on a licence. Well, they'll say, right, we're going to do you for perverting the course of justice. However, if you hold your hands up, we'll just do you for obstruction. Because again, like I say, you're under no duty to assist the police, but it is an offence to effectively mislead them or make it harder. So, so he says, did you see where those suspects went? You're entitled to say, I'm not telling you. No, I'm not cooperating, but you can't say he went that away if he actually went that away. So yeah, so that's the thing. So I think In terms of, and I'll venture a little bit of opinion, I don't want to get too embroiled in this. I think he was very lucky that the judge decided this was A2, not A1. So he got a bit of a let off there. And I think the judge was a bit generous with the, I'll suspend it because of, the effect it would have on, your charity work and things like that. I think actually if he wanted to suspend it, he should have just done it on the rehabilitation thing. He's probably better out just keeping his nose clean. He's a 58-year-old guy. He's never been in trouble before. If you send him off to prison, he'll just come out of prison because they're academies of crime. He'll come out even more, a better criminal or more radicalised or whatever like that. And we're going to give him some probation and make him go to anger management or make him go to Think First or something like that. I think that it was open to suspend this, and I think also the age counts a little bit. If this had been some young teenager or some young herder, I think they would have gone inside. But I think it's, well, you made it nearly to pension age and keeping your nose clean. So we have this idea of the social balance sheet. It's like you do something bad, so you must be penalised, but we'll also take into account anything good you did and offset them. So I think there's a little bit there. But I think that the main reason he was very lucky is the charging decision. I can't see for the life of me why he was not charged with the threatening offence. And also I can't see why he wasn't done separately for the attempt to pervert the course of justice. I mean, the judge said, I do find that is an aggravating factor. So he said that's nullified. I've given you the discount for pleading guilty, but I'm removing the discount for pleading guilty because you attempted to pervert the course of justice. So there you go. But yeah, I'll just be very interested in all your thoughts on this. But as always, hope you found that vaguely interesting, vaguely informative, and vaguely accurate. And like I say, I'll put a link to the actual judge's comments down below so you can get the full picture.